the landlord is being denied his ability to show this person's lying. This person has to come and bring evidence. They can't just declare themselves to be COVID affected. All right. Hello, everybody. Glad to see you guys coming on in. Thanks for joining us. So basically, we're here, everyone knows, to talk about the County of Los Angeles's extension of their eviction controls that occurred January 25th or 27th. And basically how it impacts what we're doing, how it interplays with the city's continuing moratorium, and basically what some of the problems with the extension are, because they've made some admissions that we actually, I think, talked about last time they extended this, which finally they admitted that they did some things that were wrong legally. And I think they're continuing to do some things that are wrong, and basically ways that you can theoretically challenge that. So what I'd like to do, I know that probably the majority of you are in the residential business, meaning you're dealing with apartments. And we're certainly going to get to the residential stuff. I want to start with the commercial stuff, mainly because it's one of the only piece of good news in the statute. And it kind of shows that they're starting to crack. They're starting to realize that they're running out of time with passing illegal moratoriums and illegal ordinances. So basically what the county did is they finally admitted, and they kind of buried it because I don't think they were very happy about admitting it. I want to show this to you. Let me share my screen for a second here. The fourth page, they buried this right in the middle. And if you guys look, it says right here, and we're going to talk about phase one. They're saying, blah, 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 while allowing commercial eviction protections to expire on January 31, 2022, due to a reinstated state law preemption concerning commercial tenancies. They buried this in here. There is no state law that came in as of January 31. The state law came in as of September 30th. And the reason is that, generally speaking, no local entity has any right, as a matter of state law, to regulate commercial evictions or commercial leases. How do we know? Because it's the law. It's right here. It is Civil Code 1954.25 through 31. And one of the things it says is, for example, you're not allowed to have commercial rent control anywhere in the state of California. They declare it as a public policy. The legislature finds that the price charge is a matter of statewide concern, and these price controls discourage expansion of commercial development, which is true. So they said no commercial rent control. If you're a local entity, you can establish that certain kinds of notices be given, right? So a public entity can establish a requirement for notice relating to a termination of a lease. So in other words, if a county wanted to say you have to write such and such and such if you're terminating a lease, okay, fine, as long as you follow these rules. Not really relevant to our conversation. What is relevant here is this: no enactment shall provide or be deemed to provide, one, for an extension of the term of any lease. So in other words, the county or the city is not allowed to force you as a commercial landlord to extend your lease with your commercial tenant. They're not allowed to require you to negotiate an extension or renewal of the lease. And here's the kicker: they're not allowed to bar any action brought to recover possession, whether by ejectment, lawful detainer, other lawful means. What that means is the local counties and cities are not allowed to make up new rules for commercial tenancies or commercial evictions. So the question is, how are they doing it for the last 2 years? Well, what happened was, when the emergency happened, this is a state law, so the governor, who's the executive of the state, suspended that law under his emergency powers. He says right here, this is the original order, N2820, that came out in March of 2020. So any provision of state law that would preempt or otherwise restrict the local exercise of the police power to impose limitations on residential or commercial evictions, and see, he references 1954.25, that's the law we were just looking at, is hereby suspended to the extent it would preempt or otherwise restrict such exercise. So he had these limitations, these exist in the law, he suspended them, the governor, which he's allowed to do. Now notice, The only thing he ever restricted here is when the only thing he allowed for is when the basis for the eviction is non-payment of rent and it's caused by a COVID-related reason. That's all he allowed them to do. That was it. It's the only thing you're allowed to do. That's the only thing he suspended it for. The county didn't just do that. Initially, they limited the commercial evictions just to non-payment of rent. When they extended it back in September, they also put in that you weren't allowed to evict a commercial tenant on a 30-day notice when they're month to month. They were never allowed to do that, according to this. That was entirely illegal from the get-go. And then going back to the non-payment of rent thing, the N2820, this order got extended every few months until finally in September 30th of 2021, the governor stopped extending this suspension. When the suspension is over, that means the law, the actual law, gets put back in place. Once the law is put back in place, any local control on commercial leasing or commercial moratoriums expires. So when the county back on September 28th did this, extended these commercial protections through today, that was entirely illegal. And they knew they were doing it. And now they're trying to come in and say, well, yeah, the reinstated state law, as if it got reinstated as of January 31st. This is nonsense. It got reinstated as of September 30th, and they took us all for a ride. So as you can tell, I'm not particularly happy with this because they knew they were doing it wrong and are only admitting it now. But at least they're admitting it. So the basic the takeaway is that as far as commercial evictions, that's all back on the table. Non-payment of rent, month to month, holdovers, everything's back on the table now. The one thing that they are still asking, or the one thing that they are requiring you to do, is if you have a commercial tenant that has less than 9 employees as of March 9th of 2020, you have to give them some sort of written notice of, you have to give them, I'm sorry, there are people coming in. Just got to stop the screen share. Okay. There's no specific deadline. It doesn't say you have to give the notice to the commercial tenants by a certain date. It just says after June 22nd of 2021, you have to give it to them. So if you haven't done it, you do it. If you need a notice, let us know. We'll help you draft one. The other thing that they're doing, which they're keeping, which is again still illegal, is they're basically saying that if you have a commercial tenant who has less than 9 employees, and that commercial tenancy is subject to a personal guarantee, you cannot sue on that personal guarantee. You might be asking, what does that have to do with evictions? Nothing. The answer is nothing. And it's not a lawful ordinance. There is a provision in the United States Constitution called the Contracts Clause, which basically says no state, and the state includes its sub-entities of counties and cities, is allowed to make a law or a regulation interfering with private contracts, which is exactly what they've done. Now, of course, there are 1,000 laws that interfere with contracts because there's a 3-part system. There's a 3-part rule analysis that a court goes through to decide if you're violating the Contracts Clause. I won't take you through the whole thing because I know that you guys aren't necessarily constitutional scholars, but basically what the state has to prove, or here the county would have to prove, is that they have to have a very significant and legitimate purpose behind the regulation. It has to be remedying some sort of broad or general social or economic problem. There is no broad or general social or economic problem of landlords going after personal guarantors of leases where the tenant is not paying the rent. This is not a massive global or American or even statewide issue that needs to be remedied by the county coming in and getting into the middle of your business with a personal guarantor, because it has nothing to do with the lease. You can personally guarantee any contract. It has nothing to do with evictions. As far as I'm concerned, it's a completely illegal law. If you were interested in having us pursue one of these cases, I'm happy to do it because I think it's an illegal law. They're way overstepping their bounds. You might get involved in a very large constitutional battle. and I'm happy to do it for you. So that is basically what's going on with the commercial evictions. Essentially, they are back on. So we're going to get into the meat of the issue, which is the residential evictions and how this works. This part is a little bit complicated. They've divided it into 3 phases. The problem is the first phase really has 2 phases inside of it. What they're calling phase 1 runs from February 1 until May 30th of 2022. The problem with this is that for the first part, which is February 1 till March 31, the county is still subject to the state law, which overrules it or preempts it, as far as restrictions on residential evictions for non-payment of rent. So, how did we get here? There were a series of state laws that got passed by the state legislature, signed by the governor, doing things the proper way, and were statewide. The last one was AB 832. You guys might remember that got passed in September. And that was the law that essentially phased out the statewide residential eviction moratorium, but provided for this 6-month post-transition period from October 1, 21 till March 31, 22, where you could start giving regular 3-day notices, but you had to put in the information about the housing is key. That much we all already know about. What that law also said was that no local entity, like a city or a county, could extend or change their laws that were already on the books at the time until March 31. So in other words, whatever you had on September 30th, that's what you have to keep until March 31. And what the county had was a law that expired on September 30th with regard to residential non-payment of rent evictions. So they basically said, all right, we give up. We can't do anything. And in September 30th, they eliminated the county-wide moratorium on residential evictions for non-payment of rent. That's important because that's all we're talking about right now. We're still in that period, but they have now expanded their county. So we have this overlap period within phase 1, Feb 1, 2022 till March 31, 2022, during which, technically speaking, you can still process your non-payment of rent evictions against residential tenants. The problem is that April 1, which is the second part of the phase 1, they're bringing those restrictions back because they're no longer preempted. The way the state law is written is unfortunately clear and nonsensical, but still clear, that the preemption only applies until March 31, which means there's nothing really preventing the county from bringing back a restriction that they had already had to get rid of, which is exactly what they're doing. So the second part of phase 1 is April 1, 2022 till May 30th, 2022, where we are unfortunately taking a step backward and reimposing the restriction of non-payment of rent evictions against residential tenants who have a COVID-related circumstance causing their inability to pay rent. Now, they also say that the landlords have to accept and the tenants may provide a self-certification regarding their COVID circumstance. And I think we've covered this in the past, but despite the county saying this, this is once again illegal. And this issue has already been addressed by the Supreme Court. I'm going to share my screen. So this is a law, this is a case called Chrysalis v. Marks. It pertains to a New York law, which is almost identical to the California one we had, where tenants could self-certify that they were COVID affected and therefore immune to being evicted for not paying their rent. And this is the United States Supreme Court basically saying this order enjoins the enforcement of Part A, which is exactly what I was just talking to you about, Because it says if a tenant self-certifies financial hardship, Part A generally precludes a landlord from contesting that certification and denies the landlord a hearing. And here's the kicker. This scheme violates the court's long-standing teaching that ordinarily no man can be a judge in his own case consistent with the due process clause, because due process generally requires a hearing. Basically, what they're saying is that you can't have a situation where the law says you get a right if you qualify for A, B, and C, and then you just have to come and say, yeah, I qualify because I say I qualify. And then you don't get a hearing as to whether or not that person's telling the truth or not. In other words, the landlord is being denied his ability to show this person's lying. This person has to come and bring evidence. They can't just declare themselves to be COVID affected. We have the exact same law. It's a self-certification. So you see here, the county is taking what the Supreme Court is writing and saying, nah, we don't think so. And the judges are buying this, unfortunately. The judges a lot are saying that, well, that's just a New York case, which is not true. It's the United States Supreme Court. When the United States Supreme Court makes a law, it's the law for everyone. It's the law of the land. That's what they teach you in law school. These are the last deciders. They are the top of the chain. So again, we take the position that we will file these cases and we ask the courts for a hearing. A lot of the time, the courts, even if they grant us a hearing, they will simply kind of take whatever the tenant says for face value, even if they don't necessarily bring evidence. So they'll basically say, fine, you want a hearing? We'll have a hearing. Tenant, what say you? COVID, affected. And unfortunately, that's the way it goes. But if you have a really good reason for believing that they're really not COVID affected, every now and then you can get a judge to say, yeah, this person doesn't seem like they're really affected. They're rare circumstances. They are case by case. We would have to have a conversation about it and tell you if it's worth it for you. But these are things that at least our office is willing to do for you. So that's pretty much how phase one works. All of the other restrictions that never really went away, namely the restrictions on no-fault evictions, unfortunately, those stay. And that kind of continues into also phase two. Phase two is June 1 to December 31 of 2022. The big change here is that now the non-payment of rent protections only apply to people who are making 80% or less of the AMI, the average median income. Now, we looked this up today. And basically, average median income for one household in 2021 in LA County is $56,000. Shout out to my client who corrected me on that yesterday. You were correct. For two people, it's 64,000. For three, it's 72. Goes all the way up to 8, and it's $105,600. So basically, if you have a person who's making 80% of those numbers or less, they continue to be protected through December 31, 2022. We have the same issue here with self-certification. The law provides them the right to self-certify their income. We think they should have to prove it if they're going to have this level of protection for the next, what you're going to see is a year and a half. The rest of the protections in terms of no-fault evictions also continue into December 31, 2022. And then what we have starting January 1, 2023 through June 30th is essentially the phase out. So that basically means that the protections for the people who are making less than 80% of AMI for non-payment of rent evictions, those continue. However, all the other eviction protections for residential tenants are lifted unless the board extends it. But as it stands right now, July 1st, 2023, January 1, 2023, you could start doing no-fault evictions in the county. Sorry, everybody. Can everyone see me again now? Okay, sorry about that. Anyway, what I was saying was, so January 1, 2023, you could start doing your no-fault evictions as far as the county is concerned. And July 1, 2023 is when all of the eviction controls go away, as far as we know now, unless the county decides to amend this. So that's pretty much most of the big changes. There are certain other changes that we can go into maybe one-on-one if you have specific questions about it. They mostly have to do with owner move-ins and certain evictions for when the evictions for not allowing you to come into the property would start to get phased in. Again, I don't necessarily think it's something that the majority of the audience is specifically concerned with, but if those sorts of issues for owner move-ins and other kinds of evictions are of interest to you, we can certainly talk about it off screen. So that pretty much is the county. And the question is, what happens between the county and the city of Los Angeles if you have the property in the city of LA? So the city of LA's moratorium has never changed since May of 2020. It pretty much prohibits any non-payment of rent, eviction against residential or commercial tenants, and also no-fault evictions against residential tenants. How does that interplay? Well, as we just discussed, our belief and the county's admission is that all of the commercial evictions, really, the restrictions should have gone off as of October 1. The city hasn't amended their moratorium to say that, but that's what the law seems to say. So that's how you address that. The city never had any limits on commercial no-fault evictions. So in other words, when the commercial tenant is month to month. So those seem to be consistent. The city and the county now allow those expressly. In terms of residential, so the county is basically now saying that as of January 1, next January 1, they will allow for the no-fault evictions. The city doesn't necessarily say that at all. The city is basically just on a month-to-month basis, every 30 days, voting to extend their existing moratorium plus their rent freeze. For the most of the last 22 months, they have been voting 14-0 unanimous to do the extension. The last time they voted in early January was the first time you started seeing cracks. Two of the council people voted not to extend it by 30 days. Now you're saying 2 out of 14, who cares? They still won. Yes, but the fact that at least a few of the council people are starting to see that these restrictions are no longer rationally related to the situation on the ground is very good news. It's a very good sign that at least they will start talking to the other council people. It's a sign that people in their districts are talking to their council people, especially business owners, and I'm sure it's small business owners saying, look, you can't keep doing this. This doesn't make any sense. Because even though the way the moratorium and the emergency status is affecting us is certainly very known to us, the emergency order also affects a whole bunch of other parts of the city's business and how the city does business with its citizens and constituents. And that's also still gumming up the works in terms of the city getting back to normal. There are a lot of people, political inclination notwithstanding, people on both sides of the aisle who are starting to say, you know what, forget it. We all got it. We're all gonna get it. Let's just live with it and go back to normal. Everyone seems to be saying that. And I think the council is starting to listen. So let's say in 3 or 4 months, they decide, all right, the city emergency is over. We still have a bit of a problem because the county will still have its restrictions on no-fault evictions. And the no-fault evictions is really what a lot of us are interested in, because you have people who have an Ellis or who have owner move-ins, landlord move-ins, resident manager move-ins that they want to do that they're prevented from doing. So we'll pretty much just have to see at that point whether the county will be put under any pressure to amend their ordinance if the city decides we're going to end our emergency. Because for all practical purposes, the county has just extended their emergency status for the entire rest of the year, which even the city of Los Angeles hasn't done. So that's pretty much where we are in terms of the city and the county interplay. I'm going to start doing the questions if we haven't already answered them. So I'm just going to start at the top. All right, so Kai is asking, what should I do if my tenants didn't qualify for the Ewrap because their income exceeded the program limits? Well, the bad news is if they didn't qualify, you're not going to get paid from the state. The flip side is that if your tenant didn't qualify, um, notwithstanding any of the restrictions that we just talked about, whether in the city or the county of Los Angeles, and I don't know if your tenant's even in the city or county of Los Angeles, but if they didn't qualify and you have a written denial letter, you are allowed to now proceed with your 3-day notice and eviction. You're saying it's Los Angeles City? Okay, so even still, if you have a tenant who didn't qualify because their income is so high that it exceeded the limits, you have basically you have a fairly well-off tenant, and so it's very unlikely that they would qualify for the COVID protections of the city or the county. And so for that person, I would just do your 3-day notice and start your eviction. So if your tenant refuses to cooperate with Ewrap, again, they are subjecting themselves to eviction. The way the statute works right now until the end of March is that you give a tenant 3-day notice, and in that 3-day notice, it's got the little box that says, please go to Housing is Key, go collect your free state money. If they don't do that, so you file your 3-day notice, by that same day, you should have already done your part of the Ewrap application. Now you have to wait 20 days. If during those 20 days, your tenant doesn't let you know that he filed his part of the Ewrap, or the state doesn't send you an email saying, yes, the tenant filed his part of the Ewrap, that basically means your tenant's not cooperating. Day 21, proceed with your eviction. And the way that I look at it is if the tenant doesn't even care enough or knows that he doesn't qualify and therefore doesn't want to lie on the Ewrap application, then chances are you're not COVID affected. You can pay the rent. So therefore, you're deciding not to pay the rent and you're subject to eviction. So Josh is asking, when will the Ellis Act evictions be allowed for the RSO units? Once again, as we just discussed, it really depends on when the city lifts its emergency. And if the city lifts its emergency before January 1 of 2023, then we would have to see if the county makes an amendment to their existing ordinance that we just discussed to allow for that. Again, there's an issue of legality here. The Ellis Act is a state law. And so the cities and the counties really shouldn't be able to stop Ellis Act evictions, because what you've essentially done is defeated the whole purpose of the Ellis. The purpose of the Ellis is that if you're a landlord, if you own a piece of property, and one day you wake up and decide, you know what, I don't want to be a landlord anymore. I want to be out of the landlord business. I want to demolish my building and make it a park. I want to not have tenants anymore. I'm just going to move all my family members and cats and dogs into my apartment building, or I just want to let it just sit there just because I feel like it, right? You have the right to do that. It's a state law called the Ellis Act. You follow certain rules, you give them certain notice, you pay all the tenants a certain amount of money. It only applies to the people who are already month to month, but barring all of those restrictions, you have a right to do that. And what the city and the county have essentially done right now is strip you of that right. And again, I believe that's illegal. Problem is, this is not something we can necessarily challenge in a regular old one-off court battle. This is something where you'd have to sue the city or the county directly. And those lawsuits are pretty much, one of them is already going on. It's the AGLA lawsuit, which is currently at the Supreme Court. They have not gotten certiorari yet, which basically means that they are applying to have the Supreme Court agree to hear the case. Those briefs are still going on. It's highly contested. There's lots of amicus briefs being filed on both sides. Once the Supreme Court decides, hopefully, to take the case, then you'll start to see the briefs for the actual Supreme Court hearing, and then you'll have a hearing sometime in the next session. So even if they do get picked up by the Supreme Court, we're pretty much very far off from hearing a decision. But anyway, you'd be basically starting at the beginning of something similar to what AGLA already started back in June of 2020. So welcome to it, but it's a very long process. Would I be interested in representing California landlords in a class action lawsuit? It's certainly possible. I think it's warranted, and Kai, that's definitely something we can talk about off screen. All right, February, March, can we still evict tenants due to non-payment of rent? The law is not clear to me. Okay, so basically what happens is February 1 to March 31, like we discussed, technically the county can't stop you from processing the evictions. But by putting the restrictions back on April 1, it basically means that if you don't get to a judgment by March 31st, on April 1st, the tenant can come in and say, I have a new affirmative defense. I have a defense now, a defense I didn't have yesterday on March 31, but now I do. And technically the judge can let them use it. So what it means is that you have to not only file by March 31, your case has to have a judgment entered by March 31. Otherwise, the tenant is going to be able to jump in and say, I'm COVID affected, and now I have an excuse. So for commercial, is that in LA County only, or how does it affect commercial tenants in LA City? So the county has expressly admitted in black and white, we are preempted from having any more restrictions on commercial evictions. The reason they're preempted is because of the state law, and that state law applies equally to the county as it does to the city. The city is not being honest and coming out and actually saying it and amending their moratorium, but there's really no reason for the city to not be preempted when the county is preempted. So as far as I'm concerned, yes, it applies countywide, and it even applies in the city of Los Angeles. You can do commercial evictions. You might have, by the way, just to be honest, you will have commercial tenants coming in who are in the city of LA saying, I have this defense under the city moratorium, and we will say, it's preempted. So do you have a link to any online summary for our current eviction increase law for non-rent control residential? We don't really have a summary. I think it's probably something we can put together, but unfortunately, Joe, we don't have that necessarily handy. If you have specific questions, we're certainly more than happy to talk to you off screen. So Gerardo is saying, my parents used a rental form from 1990 line. It stipulates no children. It's illegal now. Will this compromise my eviction case? Should you update your agreement? So no, not really. If you have a lease that has become illegal as a matter of passage of time, we got to take a look at your lease and see if it has what's called a severability clause. Most leases have them. Most contracts have them. And what it is it's a clause that says if any part of this lease, if one paragraph becomes illegal as a matter of new laws coming through, we'll just consider that one little paragraph to be stripped out. The rest of the lease remains in place. So no, I would not say that that renders your lease illegal or ineffectual, probably. Should you update your agreement? Yes. If you have a 1999 lease and it still says no children, chances are the problem with your lease is not that illegal part. It's all the other stuff that's missing now, and namely landlord protections. So if your tenant is willing to sign a new lease, that's definitely something you should look into. Okay, so and then Amber had a question about what the notice is. The county doesn't really specify. I don't know if they've actually put out a handout, but the law says you have to give them notice of their rights under the moratorium. Technically speaking, now that I think about it, they really have no rights under the moratorium anymore. They kind of did before September. So between June 22nd, September 30th, they certainly had rights. Now they really have no rights other than the right to get the notice. And technically speaking, you would have to give them notice that a commercial tenant with less than 9 employees, their personal guarantor can't be sued. From my perspective, if I was giving notice like that, I would say, here's the notice I have to give you. I don't necessarily agree that you have these rights, but here's the notice anyway. And we could certainly talk about that again off screen in terms of what specific kinds of notice to give, but as of February 2nd, they really have no rights other than those two we just mentioned. All right, when the state eviction moratorium was ended in September of 21, from October, tenants were responsible for 100% of monthly rent. That's true. Our tenants responsible 100% of rent for February and March 2022. Yes. So in terms of the whole notion of them only paying 25% and then having the rest of it turn into consumer debt, that whole business is gone. There is no such thing anymore. As of October 1, that whole business is gone. They are still responsible for 100% of the rent, right? So if you want to go and file a civil complaint against them, or if you're doing your 3-day notices, it's 100% of the rent that they own. If tenants get approved for housing is key and then get paid, and then they continue to not pay rent, what's the process after that? So it's pretty much the same process. If they get approved and they're not paying the rent, you basically have to wait until the process is complete. So that basically means that you've gotten paid. Once you've gotten paid, essentially that part of the process is complete. You do a new 3-day notice, and if they still have access to more funds, if they haven't used up their 18 months, and if the state still has any money, you could do recertify. Tenant can recertify. You can start the whole process again. So what would happen if we apply for Ewrap after we have a file in eviction? If you apply for the Ewrap after you have a file in eviction, that's fine. So if you have the eviction in process, and if it's a non-payment of rent eviction, chances are you've already filed the Ewrap when you gave the 3-day notice. So I'm not sure, Maria, if we're talking about an eviction that is for non-payment of rent. If you've applied for the Ewrap, but one way or another, if it's non-payment of rent and you've applied for the Ewrap, your eviction might get stopped if the Ewrap comes and says, okay, we've accepted the tenant's application and your application, and we're now pending. The tenant can then come in and say, oh, I have a pending application. We need to stop the case. And chances are the judge will at least stop the case. Are you able to charge late fees? No, not really. In the county and the city, not really. How are evictions allowed when the HCID website says tenants have a year to repay their rental debt? Okay. HCID is being intentionally obtuse. What the city moratorium says is when the moratorium is over, when they lift their emergency status, the tenant will have 12 months from that date to pay all the rent that was accrued during the emergency period, right? And that emergency period is still continuing. But the reason we're able to do evictions right now has really nothing to do with the rent, with how long they have to pay rent. It has to do with whether or not they're protected now. So let's say someone didn't pay rent during 2021. Let's just say. But now they have a job, right? And you give them a 3-day notice for January rent. They have to come and show that for the January time, they were not able to pay the rent. And the fact that they couldn't pay the rent for 2021 is not necessarily relevant to that particular conversation. Also, you have the difference between how long the eviction moratorium is continuing and how long they have to pay rent after the moratorium ends. Those are two different things. So let's just say right now, county notwithstanding, let's just say the city woke up today or next week, votes, we're not extending the moratorium anymore. February, moratorium is over, okay? That means that as of that time, everyone now has to not only pay the rent in full, but they will no longer have a defense for not paying the rent for that time going forward. And then if they did have a defense for all the 2 years before that, they would have 2 years to pay the entire 2021 rent until you could evict them for not paying it. It doesn't mean the actual moratorium is extending the whole time. It just means they get 12 months to pay the old back rent, but they'd have to start paying the new rent in full, and no one would have a defense. So right now, people still have a defense, right? But they have to come and prove their defense. starting in February in my hypothetical situation, no one would have a defense, but they still would with regard to the prior rent. So just to clarify, I hope that clarified it. So from April to December 2022, tenants do not need to pay any rent, correct? Not exactly. So again, it's not that they don't have to pay rent. It's that if they are truly COVID affected and the reason they're not paying rent is related to a COVID circumstance. And just briefly, a COVID circumstance is they got COVID and couldn't go to work. Their family member got COVID and they had to take care of them, or their family member couldn't go to work and that's what they rely on to pay the rent. The school was closed because of COVID, and as a result, they had to choose between paying the rent and childcare. So they used childcare and now can't afford to pay the rent. These are all of examples of honest to goodness COVID circumstances that would constitute a defense. If a person doesn't have that kind of defense, they still have to pay the rent. And if they don't, they can be evicted. It's not a free-for-all. It's not a no one has to pay rent in LA County, have fun, blow it on the Carnival cruise ship. It doesn't work like that. They still have to have some reason, a COVID reason for not paying the rent. There's no percentage requirement like we had in the past. Correct. That whole percentage requirement was part of the state eviction moratorium scheme that ended September 30th. So Stephen has a tenant that has not paid rent since the beginning of COVID. They qualified and we got the Ewrap fund 2 months ago. The tenant's still not paying rent. So once again, if that person has run out of funds, technically speaking, you give them a new 3-day notice. They would have to apply for the Ewrap. You apply for the Ewrap again, or you recertify the existing open case. And if they get denied, or if they don't fill in their part of the information, you move forward with your eviction. Gerardo is explaining that they drew up the agreement in 2015. They used a form from 1999. Okay. Also not great, but Gerardo, I think it's probably something we're gonna have to take a look at and talk about off screen. So, let us know if you want to jump into that. What are the realistic odds of getting a judgment before March 31st? Jeremy, honestly, very low, very low. It would be very, very difficult to do that. Okay, so my property manager failed to give my tenants many of the COVID rental notices the state issued over the course of COVID. Will that hurt my eviction case? It depends on how savvy they are. Most of those, you can just give them now. This is not really a big deal. Most of them don't really apply even anymore. So what I would do is just go ahead and find whatever the latest one was, which I believe was the one that you had to give in, I can't remember now because it was a while ago. Just find the latest one, give it to your tenants, and that's pretty much it. I wouldn't worry too much about it. So can we evict for past rent for October 21 to January if they missed a payment? Yeah, so again, anything after October 21, it's the rules are exactly what I just said. You have to give the 3-day notice that has the housing as key. When you do the 3-day notice, make sure you've already filed. You wait 20 days to see if the tenant has filed their part of the Ewrap. If the tenants filed their part of the Ewrap during the 20 days, that's where you stop. You have to wait for the Ewrap process to conclude before you can even file your eviction. If during the 20 days they have not filed for their part of the Ewrap, day 21, you can proceed with your eviction. And once again, I just want to clarify, still subject to if they have a COVID reason for not paying rent, your eviction might get stopped or your eviction might fail. But theoretically speaking, you have a right to file it. Can we evict anyone in the city of Los Angeles for non-payment of rent? Yes. If they don't have a good COVID reason, they are not protected by the ordinance. So if you have someone who's making a lot of money and is just messing around with you, just thinking, I don't have to pay the rent just because I don't have to, and you see them driving around in their Maserati and going on vacations to Hawaii, you should evict that person if they're not paying the rent. So moratorium got extended to the end of the year. Yes. So what we just talked about is the fact that the county moratorium did pretty much get extended to the end of the year to a degree, except for that it changes to the 80% of AMI in June. In terms of the cities, again, the city is being intentionally obtuse. They're trying to make people think that the moratorium got extended for a year. It's not. The moratorium gets extended on 30-day basis every month. And when they finally decide that the emergency is over, the moratorium will be over. And then the rules about how long you have to pay the rent will start to kick in. But when the moratorium is over, it's over. And the city does not have some sort of specific extension. It's indefinite in 30-day periods. Can we still file a small claims court and pursue collections? Yes, absolutely. Since November 1, you can go to small claims court or you can go to regular civil court and start collecting. Here's the deal with the small claims. If you are trying to collect any money that became due for residential rental debt, which accrued between March 1, 2020 and September 30th, 2021, you can sue for any amount of money in small claims court. The limits do not apply to that case. So for that period of time, residential rent money, you can go and file a $1 million lawsuit in small claims. I don't know how many of you have people who owe $1 million, probably not a lot. But theoretically speaking, if you did, you could go and file that claim in small claims. On top of which, if you are a landlord with lots of cases, the usual restriction that says you can only file 2 inside of a 12-month period does not apply when you are trying to collect the COVID rental debt, which again is March 1, 2020 to September 30th, 2021. COVID rental debt, no restriction on the limit of the lawsuit, no restriction on how many lawsuits you can file to collect that kind of debt. Starting October 1, 2021 rent, none of anything I just said applies. So you have all the old restrictions on small claims, which means that if you are an individual suing in small claims, your limit is $10,000. If you are a non-individual entity, corporation, partnership, LLC, etc., your limit is $5,000, and you can only file 2 cases in any 12-month period, right? So theoretically speaking, from October 1, you can only do the 5 or the 10,000 limit and only 2 cases. From before that, going all the way back to March of 2020, sky's the limit for COVID rental debt. Not for anything else, but for COVID rental debt. In terms of regular civil cases, again, there really are no limits anyway. File as many cases as you want for as much money as you want. If you are an entity, you will need an attorney to represent you. If you are an individual, we generally recommend that an attorney represents you because it's regular civil court. You're expected to know all the rules. Not something I would recommend a lay person go into without an attorney. We do those cases. So if you need to file 1 or more of those cases, please reach out to us. We can help you out. Kai is saying clear as mud. Mud is clearer. Yes, I understand that this is very, very confusing. I'm not a conspiracy theorist, but I do believe they make it confusing on purpose because the protections are for the tenant, and figuring it out is pretty much laid at the feet of the landlords. And you guys aren't lawyers. You shouldn't have to be able to figure all of this out. But that's why we're trying to do it for you. If you have specific questions, specific concerns, or you want to go through it again, you're confused about any specific parts of it, we're more than happy to let you guys know, to talk to you guys and clarify things, help you through the process. We are here to help you through this very confusing time and this very unfair time, and see if we can get you any sort of, I wouldn't call it justice, but at least some sort of monetary relief for your business. Okay, if a tenant is denied by rent relief program during April to December 2022, can you file the eviction? Okay, so the whole waiting for Ewrap, that stops after March 31. So April 1, despite the fact that in the county, certain restrictions are coming back, there are certain restrictions from the state which are now expiring. Namely, from April 1, you do not have to wait 20 days anymore. You don't have to file for Ewrap. None of that stuff applies from the perspective of the state. So April 1, you give your 3-day notice, they don't pay. After the 3 days business days expires, you can go straight to court. So tenants who are nuisance or subleasing, there are no restrictions. I won't say no. There are very, very, very few restrictions on evictions against tenants who are doing subleasing, assignment without the landlord's permission, using the premises for an illegal purpose. The only nuisance really restrictions is if they come and they say, well, the only reason we're making a nuisance is something that's COVID related. Generally speaking, the only thing that would really be nuisance and COVID related is if they've had to now take in their family members or their friends who got kicked out of some other place and had nowhere to go. Now they got, 5, 6, 7, 8 people living in their apartment. Maybe the kids are a little rowdy. It's the only real COVID related nuisance that I can think of. No one to date has brought us a case that was a nuisance where the tenant could say it was COVID related. If you're renting your house in West Hollywood and every single night you're having 57 of your friends over till 3 o'clock in the morning, that's not COVID related. You're getting kicked out. And that's what we did in a specific situation like that. If you're subleasing without the landlord's permission, that's not COVID related. And that's not even a defense for subleasing. So all of those evictions, free to do them. Can you ask the tenant for documentation if they're saying they don't work due to COVID? So you can ask, I would ask if I were you. They don't have to give it to you, but if you file the eviction and you ask for a COVID hearing, then theoretically speaking, they could just come and bring the documentation at that time. So at some point, they're going to have to show the documentation, and you might want to tell them that. And you say, look, I'm going to ask for a hearing. So unless you show me some sort of documentation, I'm not necessarily going to believe that you're COVID related. That's what I would tell them. You evict a tenant on Section 8, who will soon have a voucher revoked by housing for not following their rules. If you're evicting for non-payment of rent, again, all the same rules apply. And if the Section 8 participant's getting kicked out of Section 8, then even the Section 8 rules won't apply once they're no longer a part of Section 8. So yes, I would say you can, not having heard any of the other facts regarding why they're getting kicked out. Theoretically speaking, yes, you can. The building is under rent control in LA. The 3-day notices and process to evict for non-payment of rent apply, correct? Yes, it doesn't matter if it's rent control. Yes, that's correct. So if we're talking about non-payment of rent, we're talking about the same 3-day notice rules that we were discussing, namely until March 31st, we have to file for the Ewrap and wait to 20 days. Starting April 1st, we don't have to do that. In the city of LA, they're going to be subject to the COVID defense, and we are going to make them prove it. Can you sue for back rent and the eviction in one case? Technically speaking, when you're doing an eviction, most of the time you're already asking for the back rent, but you can only go back 1 year. And a lot of the times, kind of like we discussed, strategically speaking, you may know that someone was COVID affected for a certain period of time, but then not COVID affected for a different period of time. We might do the eviction strictly limited to the part where they weren't COVID affected to make the eviction more effective. In that kind of situation, I would not rely solely on the eviction to get the money. I would do the civil action separately. Now, the other reason you want to do a civil action and an eviction separately from a strategic perspective is this applies in maximum pressure. You have to remember, if you are a property manager, if you are a landlord, if you are a developer or an owner, the idea of having a lawsuit in your life is not going to faze you. This is just something you deal with every day, right? For a regular person, that's not the case. For a regular person, there's a certain psychological pressure and discomfort with being involved in a lawsuit, unless that person is a litigious person. And so when you have an eviction, maybe the person thinks, all right, well, I didn't pay the rent, or maybe I've been evicted before, not a big deal. When a person's got an eviction and a civil case going at the same time, and mind you, not a small claims case, a real case with a real judge, and real lawyers, and all that stuff, that may provide the psychological pressure sufficient to make that person want to make a deal with you, A lot of the time we do this just because the tenants don't want to communicate. They think they're in charge, and so they are taking advantage of the system. And so the only way to meet that offense is to also take advantage of the system, which allows you to file both the eviction and the civil action, getting 2 summonses, getting 2 complaints, getting an action that BASTA or EDN or any of one of the free lawyers may not take on for free. That applies additional pressure, and that pressure has value. A lot of the time when someone hasn't paid and isn't applying for Ewrap or got denied by Ewrap, you're not going to get your money. And so the idea is to remonetize the unit, remonetize the asset by getting them out as soon as possible. And so you do everything you can to apply that pressure. The civil action sometimes helps to do that, but from a legal perspective, like we just discussed, a lot of the time you can go much further back and get all of the rent demanded in the civil action in a way that you can't with the eviction. Because remember, in a civil action, on a written lease, you can go back 4 years. In a UD, you can't go back more than 1 year. So can you start filing for evictions on a tenant who didn't pay the 25% owed during September 21? Yes. Yes. So they still owe that 25%. And if they don't have a COVID reason and they didn't apply for the Ewrap and all that, yes, you can certainly start filing that eviction. Leonard just put all of our information up in the chat. Does anybody have any other questions? Just write.
Yes, I do.
Go ahead.
Okay. This is Key. You pronounced it Kai.
Oh, I'm sorry, Key.
It's okay. Okay, so I worry that if we file an eviction case against my tenants, they're going to pull out BASTA or the Legal Aid Foundation and say, oh, I was affected by COVID. I just don't have any documentation thereof, but I was sick and blah, blah. What recourse do we have then?
If they do it successfully, if they really have a COVID reason, chances are they're going to have some sort of documentation. They theoretically could come to court and just say, yeah, I lost my job. And a judge, again, could theoretically say, well, sounds like a COVID reason to me. Yeah, they could do that. But if you do nothing, then the situation will stay the same. They may go to BASTA or EDN. They may also get scared and come and want to make a deal with you. It's a move that comes with a certain level of risk, but the risk is really limited to just, maybe the attorney's fees you pay and the filing fees you pay for the initial action. But if you've gotten to the point where the tenant doesn't want to apply for Ewrap, I assume isn't returning your calls, is not giving you a good reason for not wanting to pay the rent, is not making any rent payments, and is pretty much just laughing in your face, you only have 2 options: do something or do nothing.
All right, we're doing something. Okay, well, can I try to evict them by saying I want to live in the unit? Would that be a surefire case? Is this City of Los Angeles? Yes.
Yeah, can't do that at all.
No. All right.
Yeah, unfortunately not.
Hey, Niv.
Yeah.
Oh, sorry. I didn't mean to cut you off. Go ahead.
So, Key, is this a single family home or an apartment?
It's a duplex.
Okay,
one in front of the other.
Rent control duplex?
No, it was built in 2012.
Oh, okay. So I was assuming you had a rent control duplex. Well, you still can't do the no-fault eviction, unfortunately. But at least the process would be different when they do lift the emergency. So, yeah, unfortunately, you still can't do it in the city of LA.
Can you help with collections of back rent as well?
Yeah, we do that. You can file the action. So give us a call or an email, and we can talk about it off screen.
Okay. Yeah, I do have one question for you. So I had a tenant that she's been paying, she still has continued to pay 25%, and she put in another application. We've been serving her 3 days. We've put in an application, and that 21 days expired yesterday. So I fully intended to send you her file today. I know that you're saying there's a short chance that we're probably not going to get a judgment before April 1st, but my question is this. Let's say we start this eviction process and we're in this process, and then April 1st happens, and she does use that as a defense. Does it dismiss the entire case, or does it just get?
Yeah, hold on 1 second. Is her application still pending right now with the state?
It is.
And we can't even file the eviction.
Nope.
Because she's done her part. So we can only do it if she did not do her part.
Yep.
Correct. Yeah. So the way it works again is you give a 3-day notice. Someone missed the rent. By the day you give your 3-day notice, remember that most of the time you're giving your 3-day notice after the grace period. If anyone doesn't know this, you cannot give your 3-day notice on day 2 if your lease has a 3 or 4 day grace period. You must wait the full period of the grace period. Saying for everyone else. Anyway, so you're giving your notice on February 4th or February 5th, whatever it is. By that time, though, they've already missed the rent. So you can do your application. I'm just saying, worst case scenario, this is the first month that this has happened, right? So for that tenant who missed the rent on February 1st, February 2nd, you should have your Ewrap application in, right? So by the time you give your 3-day notice on the 4th or the 5th, you've already done your part. Now the 20 days starts to tick because it's 20 days from the later of when you apply and when you give the notice. So that's what I'm always saying. Apply first, give the notice so that we're not losing any days. 3-day notice, now we wait 20 days. During those 20 days, you have to have not received. It's written in the negative. You have to have not received an email from the tenant saying, I've done my part. Or an email from the tenant state saying tenant has done their part. If you have not received either of them, meaning you have no indication that the tenant has done their part, then you can file your eviction on the 21st day. But if they have already done their Ewrap before you even did the 3-day notice, then you know that they've already gotten it, so you can't file the eviction. Or if they do send you an email, or if the state sends you an email that says they did do their part during the 20 days, train stops, you must wait for the Ewrap process to conclude prior to being able to file an eviction.
Yep. What? Yeah, what do you got?
So,
I have another question.
go ahead.
Can you hear me? Okay, so like, let's say this person didn't pay the 25% at all.
Yeah.
And I had to like bother her to apply for the program. I sat her down. She finally applied. She gave me the case ID, but she's still not submitting all the documents she requires to rent relief.
Yeah.
But she had applied before for Topperman program. It was in the area of Wilmington, but they ran out of funds. And then she applied for the Ewrap program and they ran out of funds. So now she's doing the rent relief, but she hasn't paid 25%. What's going to happen with that? Like,
so the 25%, and the rent relief are kind of independent of one another. What happened with the 25% was that if they paid the 25%, right, it basically means you got that money, and then the other 75% you can never evict for. And I'm sorry, I think someone asked me about that earlier, and I may not have been clear. If they paid 25% of the rent that was due from September 2020 till the end of September 2021, they paid their 25, you can no longer evict them for the other 75%. All of that 75% is consumer debt. You can only get it in a small claims or civil action. So that basically means you've gotten their 25.
but like you said, if they pay their 25, this person did not pay their 25.
Correct.
So
Correct.
starting April 1st, we could start eviction for them.
No, you can start eviction for them today.
Okay.
Right? So basically, if they didn't pay their 25, they don't get the benefit from the state perspective of having the other 75% not qualify for eviction. Now the whole thing qualifies for eviction, but also the rent from October 21 going forward. So if that person doesn't have a COVID-related reason in the county or the city of Los Angeles, you can go ahead and file their eviction. If they have a COVID-related reason, keep in mind, they may bring that as a defense, but if they don't, they are subject to eviction.
Okay, awesome. Thank you.
Mm-hmm.
Niv, I have one question for you. I'm sorry. This is Maria from Beachfront.
Hey, Maria.
At one point, you provided us with a letter that we were serving some of our non-LA properties,
Yeah.
stating, hey, this is persuading them to apply for housing is key, right? Are we able to serve those to the city of LA now, or is there anything else we could serve to the city of LA just to push them a little?
The letters that you're talking about were basically just kind of, they were informal landlord to tenant informational notices, basically saying, hey, look, you are going to have to pay this money at some point. And the more it starts to build up, the bigger the lawsuit's going to be when we come after you. So please call us, make a plan, do something so that you're not getting hit with a $50 or $75 or $100,000 lawsuit at some point down the road. You can really send any notices you want. In the city of LA, you have to watch out for the anti-harassment statute. There's a law that got passed in August called the LA Anti-Tenant Harassment Statute. It is also constitutionally completely ridiculous. It places ridiculous restrictions on your ability to talk to tenants or say things to tenants. But generally speaking, as long as you're just giving them information and you're not sending this notice every week or every 2 weeks and putting undue pressure on the tenants, if you want to do, another round of saying, hey guys, if you don't have a COVID-related reason, you have to pay your rent or you might get evicted. And if you have a COVID-related reason, you're still going to have to pay the rent at some point. Please call us to make a plan. I think it's a perfectly reasonable and rational, so long as it's done in a respectful tone. And our firm, we do know how to do respectful tone, even though that's not the requested tone most of the time. But we do know how to do that. So yeah, doing that every so often is probably not an issue. You may want to run it by us to make sure that it doesn't tick off any of the harassment boxes, but yes, you could theoretically do that.
Okay, got it. Because I knew that was one of the concerns that your office had on us passing it out to the city of LA.
Yeah, so let's work on that together off screen and make sure that it's kosher.
Thank you, Niv.
Oh, I think we had, okay. If a tenant has paid before COVID, they just applied for assistance in January, can we file for the back monies? Do you have to wait until the assistance approves or not? You want to file for as much as you can, your first go around. Whatever they didn't file for the first go around in Ewrap, yes, as long as they have not exceeded their 18 months, and if the state still has money, you can file for previous or future monies that were not covered by the first disbursement.
Niv, I've got one question for you.
Yes, Eric, what's going on?
Are you aware of any preemptive measures or prohibitions of agents or owners doing cash for key offerings to anyone in Los Angeles? Has Los Angeles made any rules of anything regarding this?
Yes, one of the, well, kind of. Again, this is what I was just talking about with the anti-tenant harassment. One of the rules that they put in their list of things that constitute harassment is offering tenant money to leave.
Yeah.
Technically speaking, if you go by like the absolute strictest interpretation of that, if you just even come up to your tenant nicely and say, hey, would you like $50,000 to leave at a time that's convenient for your choosing? You might have harassed them, which is why, again, I believe the ordinance is extremely broad and ambiguous. It specifically places restrictions on speech, which subjects it to First Amendment scrutiny. And First Amendment scrutiny is you have to really hit a very high bar, and it has to be very specific. This statute is not specific. It's vague and ambiguous, and I don't think it would pass First Amendment scrutiny. Problem is, no one's filed a lawsuit yet. I haven't even heard of anyone getting sued for under the anti-tenant harassment, much less suing to challenge it. So there's just no litigation on. There's no law on it, other than the law itself. There's no precedent.
So because it's so broad and ambiguous, literally walking up to the door and even discussing it could be considered harassment?
Unfortunately, yes. Now, am I telling all of my landlord and owner clients don't do that anymore? No, it's a ridiculous law, right? Yep. And people are still doing it. Now you just have to be more careful and, clever about it. Yeah, a lot of people, when they were trying to get tenants to do a buyout, were coming every day, every week, sending a different person every other day, coming at all hours of the day and night. Don't do that stuff anymore. Just kind of like have some common sense about it.
Thanks for answering that. Appreciate it. Great,
Yeah.
great webinar so far. Thank you very much for holding it. I appreciate it.
No problem.
Sorry,
Yeah.
pertaining to the questions that you're answering to him, like let's say I know harassment is offering them money, but what happened if the tenant's breaking rules, like drug rules? Because I have a tenant that is breaking those rules, and when I mentioned something, she filed for harassment.
Yeah, it doesn't work like that. You're not allowed to turn your apartment into like a crack house, and then when the landlord complains about it, he say, "Oh, you're harassing me." No, you're turning the apartment into a crack house. You're not allowed to do that. So no, you if you have a person who's having a drug-related issue, don't talk to the tenant about it. Just start the eviction.
It's her children, but her children are the age of 18 and they're not in the contract. So when I asked her if she could put them in the contract, she told me they don't have documents. You're harassing me.
That's not a drug issue, though.
Well, it's because they're smoking marijuana in the property, outside, in the parking lot, drinking outside.
Well, okay, marijuana under 21 is technically illegal, but marijuana
It's legal
evictions
in
are
your home, not outside in the parking lot.
okay. Nowadays, with the Los Angeles judge, I'm not gonna really get too far with a marijuana eviction. Nowadays, drugs means, real drugs.
Okay, thank you.
Niv, we have Rick Albert with his hand up.
Yeah. Oh, sorry, Rick. Sorry, didn't see that. Go ahead, Rick.
No worries. Out of curiosity, have you dug into, now that basically we have the mayor campaign, everyone running for mayor?
Yeah.
Have you guys done any digging into like, all right, this guy's or the gal is more landlord friendly, not like, is there anything we should be looking out for when we're starting to read their bios and start deciding who to vote for? Not necessarily asking for an endorsement. I'm just asking if there's anything we should be looking for.
Sure. If you are looking for a mayoral candidate who is landlord friendly, you should definitely be looking at the state of Wyoming. Any city in the state of Wyoming. So I'm not trying to be facetious. I'll just say none of them like us. None of them. Zero. They're all different shades of bad. Mike Feuer is the city attorney of Los Angeles. And his office wrote all the moratoria. Right? No one who I've seen is even remotely landlord friendly. They're just different shades of bad. I think Karen Bass is also running, if I'm not mistaken. She's not going to be good for us. There's no one who's running who's going to be good for us. I don't want to be pessimistic, but I have to tell you the truth.
Sure.
It's just not a good situation. The only kind of silver lining to it is that we live in a really weird city where the mayor doesn't call the shots. It's the council that calls the shots.
Okay.
The mayor has a certain amount of power, of course, but in our city, the real political power is held by the collective council. And they are a mafia of sorts. Mike Bonin is not running for re-election. That's very good news.
Thank God.
Yes, thank God is right. I think the councilwoman from the 4th district, I can't remember her name. She's a young lady. She's Democratic Socialist. I think she's getting challenged. So some people are not particularly fond of how well she's been doing her job. If she gets out, that would be good news. Anyone who replaces her would be better than her. So there's a lot of kind of slivers of hope on the city council. That's kind of what I'm seeing.
So that's where the focus should be.
The focus should definitely be city council. There's just oh, you know what? I will take that back on the mayor thing. If Rick Caruso runs, obviously we would have an excellent partner in Rick Caruso. This guy is a professional landlord. So if he comes in and runs on crime, runs on homelessness, runs on, make LA great again, or the, Democratic functional equivalent, I'm going to throw a parade if he wins. So, but he hasn't really announced yet. So that's why I don't consider him, an official guy who's running. He just registered Democrat. He's putting up a lot of things on his Twitter that suggest that he wants to run. It's the only thing he hasn't done yet, because, he's a massively successful developer. He's done the residential, he's done the commercial, he's done everything. And this is kind of like, I think, the only thing he's got left to do. So do I think the citizens of the city of Los Angeles will necessarily vote for a billionaire developer running their city? That kind of sounds, I think, to a lot of people in the city, eerily familiar. At the same time, I think everyone in the city, notwithstanding political affiliation, is kind of getting tired of seeing all the homelessness and the crime, and the fact that the people getting shot are Democrats and Republicans. And the CVSs and the Walgreens that are getting ransacked are filled with customers who are Democrats and Republicans. Maybe it'll be enough to get him in. I really, really hope so.
Hey, Niv, quick question. So we have a resident that owes us a lot of money, and so this was one that is still current, and she has filed an app. So, but we've decided we've talked with you about sending her to small claims.
Right.
So my question is this, because we know that what you just said, we could send to small claims for any amount for balances, and she did have a balance in that period.
Yeah.
But my question is, like, for example, should we still accept, like, if she wants to make partial payments, are we okay to accept them for the partial payments and still sue for that past balance in that period?
Yes, that's a good question. Thank you for asking that, Amber. We have to keep in mind the separation between eviction protocols and processes and civil protocols and processes. In eviction cases, remember, the rule is that once you serve your 3-day notice to pay rent or quit, and the 3 days goes by and they didn't pay the rent, you don't take rent after the 3 days goes by, even if they want to come and pay, unless you want to take the money, and then that will negate your 3-day notice, right? So that's what we do in evictions. We don't take money because we're scared of ruining the 3-day notice and then the subsequent eviction. None of that applies in small claims. None of that applies in civil. If you are suing someone for $100,000 and they come to you in the middle of the lawsuit and say, here, take 10,000, fantastic, take the 10. Lawsuit continues as to the 90. It doesn't affect your rights in the civil case at all.
Perfect. And then does that mean that when we take her to small claims, because right now she's like at $88,000, do we have to separate and just take her to court for what she owes us between March and September? And then we would have to just do another case for anything after September, or can we put the whole balance in?
You cannot put the whole balance in. If you want to do it in small claims, it has to be March 2020 till September 30th, 2021.
Okay.
And then that's it. You cannot go for more money than that. If you want to go for the rest of the money, October till now, you either have to do, well, you can only do a civil case, because the most that CLG could do is $5,000, and she obviously owes more than $5,000 for those months.
Okay, and your recommendation between the small claims and the civil case, what would you recommend in this case? Somebody owing $88,000.
Okay, so that's a good question. Thank you for asking for that. Just so everyone understands, there's pros and cons about small claims and civil. Pros: small claims, no lawyers, at least the first go around, right? So you cannot bring a lawyer with you to your small claims case. If you've never been to small claims, it's pretty much like Judge Judy with no cameras, right? You are sitting there, and the tenant sits there. Nobody has any lawyers. You bring your documents. The judge hears your side, their side, your side, and then issues a ruling in writing later on, right? It's that simple. If one of the sides doesn't like the decision, you can appeal it. You can bring a lawyer to the appeal. The appeal isn't really appeal, it's a do-over. Basically do the entire case again, this time with a lawyer presenting your case in front of a different judge, right? And I believe other side can appeal. So that's the good thing about small claims. Another good thing about small claims is that you the filing fees are less, and you will get a trial date a whole heck of a lot quicker. So I don't know what the trial dates are now. Before it opened up to everybody on November 1, it was around 3 months. Let's say it's even more now, and you're talking about 4, 5, 6 months. That's still much faster trial date than you will get filing a civil case. So that's the good things about small claims. Bad thing about small claims is the limitation we just talked about, where you're stuck between March 1, 2020 and September 30th, 2021. And if you have funds that are outside of those periods, you cannot bring them into your small claims without going above the limit. So that's one limitation. Another limitation is that when you go to civil case, so the pro, obviously the opposite pro, is that you can do 4 years worth of rent going back on a written lease. So as much money as you want, there's no restriction. Number two, you do not have to go to the small claims case. So when you file a small claims case, good news, don't bring an attorney. Bad news, that means you got to go. And sometimes that means sitting in the court or having your subordinate or employee sit in the court from 8:30 to 4:30, only to find out we didn't have time for you today. Please come back next week. And that's happened to people where they have had to do that once, even twice, and had to come back a third time. Also, if the tenants want to screw around with you in small claims and file motions and get relief and all this other stuff, they can do that too. So the small claims case can take a decent amount of time. And every time you come, it's got to be you, right? You have to waste your time or your employee's time. Versus a civil case, bad news is you got to hire an attorney. That's going to cost you in terms of legal fees. Good news is your attorney does all the work for you. Now, opposite also is that you will not get a trial date in a civil case that is anytime soon. So if you are doing between $10 and $25,000, which basically means a limited case, they're going to put you in the limited court, and your trial date's not going to be for like a year and a half or 2 years. If you go to a regular, if you do a regular case, an unlimited case, which is more than $25,000, it depends on what judge you end up on, but you're still looking at least a year in terms of a trial date. Now, a trial is not the only way to get a judgment. In a civil case, you can send a bit of discovery. And by the way, discovery is something else you cannot do in small claims. You can do it in a regular civil case. The bad thing about discovery, costs money for a lawyer. Good thing about discovery, puts pressure on the other side. The other good thing about discovery is you can get admissions from the tenant, basically saying that they didn't pay the rent. Once you have those admissions that they didn't pay the rent, you theoretically, if the case warrants this amount of work, you can go and get a motion for summary judgment. Motion for summary judgment is a somewhat complex motion. It is a trial on the papers, which basically says, judge, based on the admissions that I've received from the other side, they've admitted enough that none of their defenses work, and they've admitted all the facts that I need in order to prove my case. Therefore, there is nothing for a fact finder, be it the judge or the jury, to find. The facts are admitted. Now, if the facts are admitted, judge, you are the only one who gets to apply the law to the facts. You don't need a trial to do this. I'm handing them to you. Here are all the facts. Here's all the law. Please give me a judgment. Right? And you can file a motion for summary judgment anytime during the case. Now, motions for summary judgments, especially plaintiffs' ones, aren't notoriously difficult to win. We've done many of them, but they are somewhat difficult because you really have to box the tenant in. It is a chess match that you have to plan several moves ahead. And because of that, it is a somewhat expensive motion as well. However, if you have someone who owes you $88,000, $100,000, $150,000 in rent, it may be warranted. And as long as you can get them to make the admissions. During the process of doing that discovery, you may have now put sufficient pressure on the other side to simply say, fine, fine, I give up, let's make a deal. So there's multiple advantages to doing a civil case with a lawyer. It just has to be economically warranted.
Okay, and you can't then charge them for the attorney fees?
Sure you can. Well, no, sorry. In most leases, in most residential leases, including yours, the attorney's fees are capped at like $500.
I think it's 500, yeah. Okay.
Right.
Okay. All right, well, that is definitely helpful information. Thank you for all of that.
Yeah. Jasmine asked, can you still evict for just cause? Yeah, most just causes. Just causes really only come in a few categories. One is not paying the rent. We discussed that. Two is breaching a material covenant or obligation of the lease. So you could still do those. And the other one is, nuisance, illegal use, and subletting an assignment without the landlord's permission. All of those are absolutely perfectly good evictions to do nowadays. Rick says, in addition to the car forms and disclosures, what language should we be adding going forward in the leases? That's like probably a whole different thing that we would have to go through. Which is actually a really good idea. We can kind of take an existing lease and break it down and make sure that everyone's got all the right sort of terms. In terms of new things, the only real new thing that California added was that, like a lot of buildings which are older and have the lead paint packet that you have to give to the tenants, now there's a mold packet that you have to give to the tenants. That's pretty much the major addition that happened. But in terms of other things that you can put in your leases to protect you, which may or may not be enforceable, we could certainly do that on a different webinar, Rick, and thank you. That's a very good idea, and we'll probably schedule something like that in the near future. Yes, our office does help with drawing up leases and rental agreements. We can provide you a excellent, user-friendly, all-in-one package that is easy to use, easy to fill out, and provides you with as much of the protections as the state law allows us to give you. So let us know, and we'll be happy to talk to you about that.
Niv, I have a quick question.
Yeah.
Jasmine here, Siena Heights. As far as the 3-day, I think I put it in there, I probably missed it there. Are the 3-day notices are they soon to change, since they were until March 31st or March?
Correct. So after March 31st, the 3-day notice you used is the one that we used pre-COVID.
Okay. And then also, because I know we actually have a couple of eviction cases with you guys right now.
Yeah.
Can we still go ahead, and if they passed that 20-day mark for the housing, applying for housing as key, can we still go ahead and proceed with the eviction? Or the extension, does that change anything?
Right, so it does not change anything. So again, the county extension really only kicks in for us on March 31st. Right now, the county extension in terms of non-payment of rent technically didn't change anything. So if you have a 3-day notice that you posted, you've done your part of the application, the tenant hasn't done their part of the application for 20 days, day 21, we're free to go.
Okay, and then lastly, I'm sorry, I have
Go ahead.
one. And last one, I did ask about the just cause. That does not include unauthorized occupants, or does it include unauthorized?
Again, the city of LA takes the position, because of the stupid way that they wrote the moratorium, that any unauthorized occupants, whether it's COVID related or not, seems to not necessarily be a reason for eviction. I don't think that's what they meant, but that's kind of the way they wrote it, because of where they put the commas and the order of the words. It gets to that level of detail. Probably we can't do it in the city of LA.
Got it. Okay. Thank you so much. Oh, well, actually, we're not in the city of LA. We're in Lancaster. So we're in Los Angeles County, but still, would that make a difference?
Yeah, because I'm pretty sure. 1 second. It has, if it's COVID related, in the county, they made it very clear. They basically said a residential tenant shall not be evicted for nuisance or unauthorized occupants or pets whose presence is necessitated by or related to the COVID-19 emergency.
Okay, so that reverts back to what you were saying about the family moving in. If, their family was affected by COVID, so they all moved in and now they're over occupancy. But if it's not that scenario, then we can go ahead and try to proceed with it, or?
Yeah, and let them come and tell us how it's COVID related.
Okay, sounds good.
There's a few questions in the chat, Niv.
Okay, let's see. Will the CA provide new 3-day notices? They might, but again, I don't think you need new ones once March 31st, comes around and we're into April 1st. The notices that we were using before COVID are the ones that we would now need to continue to use. Will new informational notices have to go out? So no, the only informational notices that are even referenced in this county, in the new county extension, was the continuation of the obligation to give notices to your commercial tenants with less than 9 employees. So if, first of all, if you don't have commercial tenants, then that doesn't apply to you. And second, if you have the commercial tenants and they have less than 9 employees, they don't even really explain what the notice is. I think the regulatory arm of the county might have published one, and you just have to now continue to give that notice.
And Niv, our last question, third from the end, from Carmine.
Oh, okay. So, is it down here? Oh, third from the end. Sorry, here it is. Okay.
If we filed like our landlord application and the resident did either didn't do their part or they got denied or didn't complete it, and we decide to go through an eviction, I know usually we have to stop serving notices, stop taking payments, but is that the same with these notices? We should stop serving notices because we don't want it to supersede.
Yes, absolutely. If you are in eviction already, if we filed your eviction already, stop serving the notices.
Okay. Thank you.
Yeah. Okay, so I guess that's it. If anybody else has any questions, all of our information is in the chat. We're happy to help out and hopefully get your evictions on file, or take care of your civil actions. Please do keep in mind our firm is a full service. It's a full service real estate, construction, and landlord tenant firm. Beyond just the evictions, we do regular litigation, we do transactional for commercial, residential, you name it, any sort of real estate related matter. If you're a developer, owner, landlord, property manager, we pretty much handle all the legal issues that impact your business. So please feel free to call us or email us about any issue that you might be having. And we're here to help out, and hopefully we can assist you. So thank you everybody for coming on. I hope it was informational. So have a great afternoon and hope to talk to you all very soon.
Thank you. We
Thank
appreciate it.
No problem.
Thank you.
Thank you.
Thank you very much. Thank you.
No problem.
Thank you.
No problem. Thank you for coming.
Thank you so much for giving us advice. Have a good day.
No problem. You too.